that there is no conclusive legitimate interest to be served by the statutory scheme. And briefly, we also went through the purpose of marriage, which is procreative. So the legitimate interest for promoting opposite-sex marriage is to provide a conducive environment for the welfare of children. And therefore, again, domestic relations law passed under equal protection review. Now, Justice K was the dissenting judgment who gave the opinion. And hers, actually, if you look at it, seems to be, in my view, more coherent. Basically, she started with what marriage is, alright? And she said that marriage is a life-defining event, one that people look forward to, or back upon as one of the most momentous events in their lives. And it is a need for people to express publicly their devotion to one partner. And she said that gay people are deprived of this solely because of their sexual orientation. So she went through the two reviews, which is domestic process clause review, and she basically said that the right to marry someone is the fundamental right to be protected. It doesn't matter who the person or what gender the person is. So she said that the fundamental right is the right to marry somebody of your choice, and that is the fundamental right to be protected. Now, so because she defined it at that level, it was a fundamental right, and under strict scrutiny, this law would fail. She then went on to criticize the majority opinion. She said, not deeply rooted in tradition. She said that rights will not cease to be fundamental simply because something that has been historically denied. And she went on to talk about basically the anti-miscegenation laws, which was not really deeply rooted in sense, and it was struck up by the courts ultimately. She also went down to look at two cases, which is Bauer and Lawrence. Now, Bauer was an earlier case where the right to engage in sodomy was not struck up by the court, and it was stated that it was not fundamental. What happened in Bauer is similar to Lawrence. Two people were charged for having sodomy in private, and the courts said that that law was not unconstitutional. How it was framed in that case was that the issue was, do the parties have a right to engage in sodomy in private? In Lawrence, the issue was phrased as, do parties have a right to have intimate private relations with someone of their own choice? So by how sometimes an issue is phrased, there is some sort of bias in the way the issue is canvassed. So in Bowers, the law was not struck out. In Lawrence, subsequently it was. Now, under due process clause review, which is fundamental rights, Justice K treated the right to marry someone of same sex as no different from the right of whites to marry non-whites. Basically, it boils down to the right to marry someone of your own choice, and the deprivation of such right is subject to strict scrutiny. Now, she also went into the history of the fight against anti-miscegenation. What happened was that, now it was only struck out in 1967, but as late as in 1948, there were 33 states that had a ban on interracial marriages. In 1957, 10 years before this case, 96% of Americans were opposed to interracial marriage. And in the 1967, when the Levin was decided, 17 states still had the anti-miscegenation law. But the New York Court still struck it out. And she said that, sadly, many of the arguments raised in support of anti-miscegenation are identical to those made today in opposition to same-sex marriage. So, what are the reasons that they gave previously to ban marriages that are not white and white? I'm sure you're pretty familiar with some of these. That mixed marriages are unnatural, they are a violation of God's will, the amalgamation of races will produce a degraded civilization, it's the laws of civilization to demand that the races be kept apart. It's quite similar to what you hear now. If you allow same-sex marriage, society will collapse, the institution of marriage will be debased. It is against God's word for people of the same sex to marry. It is immoral, it is idolatrous, it is unnatural. And in Singapore especially, gay sex itself is illegal, so how can you endorse a civil union of two people who are engaged in legal activity? Now, then the judge went down to the next review, which is the Equal Protection Review. And she said that the majority was misconceived as to analysis of whether domestic relations law passes the Equal Protection Review. Now, the majority judges said that promoting opposite-sex marriages would encourage opposite-sex couples to have a conducive environment to bear children. But she said that you have to look clearly and not the law, but whether the distinction and discrimination against same-sex marriages will serve this benefit or not. And she's of the view that the discrimination does not serve that benefit, and therefore it does not pass Equal Protection Review. There is no legitimate interest to be served in that distinction. So, because of that, she's of the view that the Equal Process Clause review required heightened scrutiny. And she's of the view that there is discrimination against gender. And she gave, I think an example was given, which is people are discriminated from marrying based on their sex. A can marry B, female, because A is female, but C cannot marry B because C is female. So this is a discrimination based on gender. Okay, so under heightened scrutiny, what does the state show? The state must show that the discrimination is substantially related to legitimate state interests. And she said that there is no legitimate interest to be furthered by the distinction. And therefore, the rights of gays and lesbians to marry only people they have no innate attraction. Okay, so what she also said is that it is no answer to say that you can marry someone of the opposite sex. Because if you cannot marry someone that you're innately attracted to, that's a breach of equal protection, because some people can marry someone they are innately attracted to and some cannot. And therefore it constitutes a violation of equal protection. So, having said that, she then went on to say, what if rational basis review was the rational basis scrutiny was the basis for reviewing the domestic relations law under Equal Process Clause? And she said that the discrimination must rationally further legitimate state interests, and the state must show that the distinction will further legitimate state interests, not just the law itself. So she held that excluding same-sex marriages from all the benefits of marriage does not encourage opposite-sex couples. In no way encourages them to have children. That means whether you grant them children or not, opposite-sex couples will continue to marry and have children or not have children, as the case may be. And she also disagreed that the main purpose of marriage is to create children or to produce a conducive environment for children. She said that the essence of marriage is actually the public expression of emotional commitment between two parties. And she said that this is not given to same-sex couples. So basically she concluded that no legitimate state interest is furthered by the discrimination. And in fact, she turned the issue on the head to say that actually the state's interest will be advanced if same-sex couples with children can legitimize their status, and the children of same-sex couples get the benefits of marriage. Okay, she also talked briefly about